All right, so good evening. Thanks to those of you who are joining live. I appreciate it. And those of you who are watching the recording, I appreciate you taking the time as well. My name is Dr. Josh Franco, Assistant Professor of Political Science at Cuyamaca College. Welcome to our workshop on American political economy. So this workshop is a new series that's focused on defining, exploring, and discussing American political economy from the point of view of different individual, group, and organizational entities at the local, state, and national level using historical and contemporary news and events. Our schedule for the summer is as follows. So last week we provided an overview of American political economy. This week we'll talk about the major questions doctrine and using American political economy to analyze this emerging and potentially decisive Supreme Court doctrine. And in future weeks, to be determined, decided yet. So if you have ideas, suggestions, comments, thoughts, proposals on topics to cover, I'm happy to entertain them and to incorporate them in a future week. So let's go ahead and go to week 2. And the topic for today is the major questions doctrine. So our learning objectives with this workshop are the following. You'll be able to describe what the major questions doctrine is, explain how the major questions doctrine relates to at least one of the 4 American political economy or APE areas, and explain how the major questions doctrine can be viewed by individuals, groups, or organizations at the local, state, or national level. So what is the major questions doctrine? So to quote a Congressional Research Service report, Congress frequently delegates authority to agencies in general or broad terms to promulgate or to create regulations that advance the goals Congress has defined. In a number of decisions, however, the Supreme Court has declared that if an agency seeks to decide an issue of major national significance, a general delegation of authority may not be enough. Instead, the agency's action must be supported by clear statutory authorization. Another way of putting that is that Congress can't just say, oh, it's up to this department or agency at the federal level to make rules about what we're talking about. Congress has to say what in general or specific those rules need to be or ought to be, as opposed to just saying it's up to the executive branch to make the rules. Courts and commentators and individual Supreme Court justices have referred to this doctrine as the major questions doctrine or the major rules doctrine, although the Supreme Court has never used that term in a majority opinion. What I'd like to bring up is that Congressional Research Service report, and we're going to let it load here. So you might be asking, what's the Congressional Research Service? So the Congressional Research Service is the nonpartisan, independent research arm of the United States Congress. It consists of dozens, if not hundreds, of staff members who are highly educated or highly trained in their fields of study or of research. They will provide background information to members of Congress, both in public settings and in confidential settings. And they are viewed as authoritative in the information that they provide to the Congress. And so this is one of their legal sidebar reports talking about the Supreme Court's major questions doctrine, background, and recent developments. So this is where we drew some of our information from. And these reports are very helpful to both elected officials, senators and U.S. Congress members and their staffs. And the reason is that it provides that authoritative background or information on a topic of interest to those members. And in this case, they're describing some of the background of the major questions doctrine, recent cases at the Supreme Court level that relate to it, and background information for those several cases. And we're going to look into one of the latest cases, which is West Virginia versus the EPA, in a few moments. Now, what I like to do is point out this section on the considerations for Congress. I'm going to have this read to us because what's nice about these research reports is that it talks about not just in general what this issue or topic is, but what does Congress need to be thinking about, or what can Congress think about or consider when they're learning about this topic. So let's go ahead and see if this can play for us, which I actually don't have it in Word. I'll go ahead and read it for us. So, considerations for Congress. Even if the Supreme Court does not clarify the scope of the major questions doctrine in West Virginia versus EPA, the increasing frequency of legal arguments about this doctrine suggests that it could continue to be an emerging and important issue in administrative law. If the Supreme Court were to adopt the doctrine as some individual justice has expressed it, then courts applying the doctrine could potentially determine that an agency lacks the ability to determine authoritatively a major question unless its underlying statutory authority, or the law that the Congress has passed, clearly permits or requires it to do so. Therefore, if Congress wants an agency to have the flexibility to address potentially complex and difficult to foresee policy issues that courts might consider to be of vast, quote unquote, economic and political significance, Congress could consider how to clearly specify that intention in the relevant underlying statute, as opposed to relying on vague or imprecise statutory language. Alternatively, if Congress wants to prevent an agency from administratively addressing certain major policy issues, it could consider how to clearly circumscribe the agency's statutory authority. To date, the court has not provided clear guidance on what can be considered a major question, or how Congress might state its intent with respect to issues that it cannot now foresee, which could complicate the drafting of such statutes. Given the recent interest in applying the doctrine, however, it's possible that the court will clarify its scope in a pending or future case. So hopefully that gives us a very clear and working definition of what the major questions doctrine is. Now, how did this major questions doctrine emerge? So I'm going to highlight a couple of themes here over the past almost century now. So in the 1900s to the 1950s, we had major public health issues, economic depression, and war. So this is the experiences that the country is going through and the people within the United States. After World War II, we saw an expansion of national power, which basically means that the federal government was passing federal laws that would affect both the states and the people living within the states. Throughout the 1970s and the 1990s, delegation of regulatory power from the legislature, in this case, the US Congress, to the executive branch increased. And then we started to see the rudiments or the roots of the major questions doctrine emerge in Supreme Court cases around the 2000s. And now here in 2022, the latest case that could unpack or open this box of the major questions doctrine, West Virginia versus the Environmental Protection Agency, is before the Supreme Court. So let me go ahead and click on that link and take us to a website called Oyez, even though it's spelled O-Y-E-Z, you pronounce it Oyez. So Oyez is a online website, a repository of all Supreme Court cases, and if available, the audio recordings of those oral arguments. So the way to read this is, West Virginia versus the Environmental Protection Agency. So the West Virginia is petitioning the Supreme Court to answer a question that they have about a case that's been working its way through the system, and the respondent is the Environmental Protection Agency. This case has not been decided, but it should be decided in the next 2 or 3 weeks, or at least at this point, they're drafting it. So what I'll do is I'll have the facts of the case read to us and the question, and then we'll listen to about 2 to 4 minutes of the beginning of the oral argument that's made in front of the Supreme Court justices. Let's go ahead and listen into this.
Facts of the case. The Trump administration repealed the 2015 Clean Power Plan, which established guidelines for states to limit carbon dioxide emissions from power plants, and issued in its place the Affordable Clean Energy (ACE) rule, which eliminated or deferred the guidelines. However, the U.S. Court of Appeals for the D.C. Circuit vacated the ACE rule as arbitrary and capricious. One of the challengers, North American Coal Corporation, challenged the Environmental Protection Agency's authority to so broadly regulate greenhouse gas emissions. Question: does the Environmental Protection Agency have the authority to regulate greenhouse gas emissions in virtually any industry, so long as it considers cost, non-air impacts, and energy requirements?
So you hear the facts of the case, right? The Clean Power Plan was developed in the Obama administration, and then when the Trump administration assumed power, they repealed it. And interest groups, economic interest groups, brought forward a lawsuit saying that the EPA doesn't have the authority to regulate broadly greenhouse gas emissions. So the question that's presented is this is the question that the Supreme Court needs to answer. And because this is a yes or no question, the Supreme Court will answer saying, yes, the EPA has the authority to regulate greenhouse gas emissions in virtually any industry, so long as it considers the cost, non-air impacts, and energy requirements, or no, it does not have the authority to regulate. So what I'd like to do is bring up the oral argument, and we'll listen to this for a few moments just to get some background on it. So I'll go ahead and play the first couple minutes of this.
We'll hear argument this morning in Case 20-1530, West Virginia versus the Environmental Protection Agency and the consolidated cases. Ms. C.
Mr. Chief Justice, and may it please the Court, in Section 111 of the Clean Air Act, Congress directed EPA to partner with the states to regulate on a source-specific level, which means identifying measures particular buildings can take to reduce their own emissions. The D.C. Circuit gave EPA much broader power to reshape the nation's energy sector, or most any other industry for that matter, by choosing which sources should exist at all and setting standards to make it happen. No tools of statutory construction support that result. First, electricity generation is a pervasive and essential aspect of modern life and squarely within the state's traditional zone. Yet EPA can now regulate in ways that cost billions of dollars, affect thousands of businesses, and are designed to address an issue with worldwide effect. This is major policymaking power under any definition. And though respondents argue EPA can resolve these questions unless clearly forbidden, this Court's precedents are clear that's backward. Unless Congress clearly authorizes it, Section 111 does not stretch so far. And Congress hasn't done so here. Second, the words Congress did use in the context where it placed them confirm Section 111's traditional scope. Read together, key statutory terms, like the requirement standards before individual sources and focused on their performance, show that Congress did not greenlight this transformative power. And finally, standing is no reason to avoid the merits. We're injured by a judgment that brings back to life a rule that hurts us and that takes off the books a rule that benefits us. Respondents' arguments sound in mootness, and it's their burden to show that EPA's voluntary cessation and a stay are enough to end the case. They're not. We're asking for the classic appellate relief of undoing what the court below did, and this Court has full power to give it. And the weighty issues at stake confirm that it should. In contrast to EPA's important but environmentally focused role, Congress and the states are able to weigh all of the competing factors and constituencies in play. The lower court was wrong to short-circuit that process here, and the Court should reverse.
So that was Lindsay C. And so she is the person arguing for the state petitioner. So in this case, West Virginia and the group of states involved. You'd also have other advocates, Jacob M. Roth for private petitioners, Elizabeth Prelogger, who's the federal respondent, and they're the U.S. Solicitor General. So they're the nation's highest lawyer. The lawyer that argues before the Supreme Court, I should say, and then Beth Brinkman, the power company respondents, who would argue before the Supreme Court. So in this 2-hour session before the Supreme Court, each of these advocates spoke on the topic. So Lindsay C. is advocating that in West Virginia's case, West Virginia wants the Supreme Court to rule that the EPA does not have the authority to regulate greenhouse gas emissions in virtually any industry. So this is like into the weeds of what's going on with this broader concept of the major questions doctrine, and in the broader concept of the AP, or American political economy. So let's explore, why this is up in front and center. So I'll pull up a news article in Politico, which is a Washington, D.C. focused news organization. And the title of the article is How SCOTUS, or the Supreme Court of the United States, upcoming climate ruling could defang Washington. And the byline is, a legal fight over EPA's power to restrict greenhouse gases offers conservative justices an opportunity to tie the executive branch's hand on a host of issues from COVID to net neutrality. So what I'll do is I'll highlight, actually I'll leave it here and we'll have this read to us, a couple of paragraphs of this article. And I'm going to change the voice since kind of change it up a bit every so often.
The Supreme Court is expected to issue a ruling this month hobbling the Biden administration's efforts to rein in greenhouse gases, but its impact could weaken Washington's power to oversee wide swaths of American life well beyond climate change. The upcoming decision on the Environmental Protection Agency's climate oversight offers the conservative justices an opportunity to undermine federal regulations on a host of issues, from drug pricing and financial regulations to net neutrality. Critics of the EPA have clamored for the High Court to do just that, by declaring it unlawful for federal agencies to make major decisions without clear authorization from Congress. The Supreme Court and several Republican-appointed judges have invoked the same principle repeatedly during the past year to strike down a series of Biden administration responses to the coronavirus pandemic. Liberal legal scholars worry that the EPA case could yield an aggressive version of that thinking, unraveling much of the regulatory state as it has existed since the New Deal. Energy and Environment. Rules at Risk. By Alex Guillen and Sarah Oermel. That has implications for other major rules that President Joe Biden's agencies are writing or defending in court, including wetlands protections, limits on car and truck pollution, insurance coverage for birth control under Obamacare, and even the Trump administration's attempts to lower drug prices. A narrow reading of what the federal agencies can do is going to literally handcuff the federal government from taking action to protect Americans' health safety and the environment, said Lawrence Gostin, a public health law professor at Georgetown University. Climate change and major questions. The immediate stakes in the EPA case are big enough on their own. Two coal companies and a phalanx of Republican-led states want the court to limit the agency's ability to regulate greenhouse gases from power plants, a major driver of global warming that threatens to worsen flooding, droughts, disease, and other calamities in the coming decades. The case's origins are messy and complicated, involving a sweeping Obama-era power plant climate rule and the Trump administration's efforts to replace it with a much narrower regulation. The original rule had sought to push the electric power industry away from fossil fuels and toward greener sources such as wind and solar, wielding the EPA's powers under a seldom-used section of the 1970 Clean Air Act. Under Biden, the EPA has embarked on writing its own version of the rule.
So this article goes on to describe what's happening and how we reached this point, both with respect to West Virginia versus EPA, and then more generally about this major questions doctrine emerging from reasoning that's been used by the Supreme Court over the past 20 years, and it's become more prominent in the past 5 years. And so with that context in mind, we ask ourselves, well, how does this relate to the American political economy areas that we talked about last week? So first, the AP area of the role of organized economic interest. Well, how this relates is that we would imagining that the Supreme Court says not only that the EPA doesn't have this authority, but that it says that the Congress can't just generally delegate authority to the executive branch. We would see a shift from national to state by state engagement by organized economic interests, because presumably what would happen is that the federal government couldn't regulate things at a national level, but that it would still leave it up to states to regulate it on a state by state level. Secondly, on the area of embeddedness of race in American capitalism, we could see, for example, the extension of this not only in the EPA, but to other issues like civil rights. So the Supreme Court rules broadly in West Virginia versus EPA. We could imagine that national civil rights legislation could be further undermined by the Supreme Court, basically saying that the federal government can't pass laws that delegate to agencies like the Department of Justice or the Equal Opportunity Employment Commission to create rules that would protect people of color or people who've been discriminated against either contemporarily and or historically to seek redress at the national level. Again, not being able to enforce things from the federal government, but on a state-by-state basis. Next, on America's spatial political economy, we would imagine that this reinforces spatial fragmentation because, for example, if each state is developing their own rules with respect to greenhouse gas emissions, we'd expect some states to be very progressive in moving forward in that direction, while some states would be regressive in trying to bring back or to support or to generate even more fossil fuels than they're currently doing. So different states have different rules and regulations around greenhouse gas emissions. And then lastly, on the fourth area of coalitional dynamics through the APE lens, we would imagine, again, a shift from national to state by state. So imagine all these national organizations have been building networks to try to pressure members of Congress, lobby members of Congress, persuade members of Congress in the Senate and in the House to pass laws and rules that promote federal regulation of greenhouse gas emissions. But if the Supreme Court takes away that tool, then these coalitions that have worked hard at the federal level all these years might say, well, our strategy is going to shift. Instead of looking at the U.S. Capitol and the nation's capital, we got to go state capital by state capital to build the coalitions, to build the grassroots organizations, to pass state level laws and regulations on our topics of interest, whether it's environmental, civil rights, housing, public health, education, and the like. So last part is, perspectives and levels and how this influences different parts. I'll talk about two levels here, and then our discussion, we can focus on the second one I left blank. So if we're thinking about individuals, right, me, you, others, right, at the local level, we would say maybe the activity depends on state laws. Like we might hear this major questions doctrine in passing, but we wouldn't really see much change at the local level. We're probably more preoccupied with street lights and roads as opposed to, what the federal government can and cannot do. For individuals thinking about the state level, I would imagine increased political activity, because if you're not having these arguments in Congress in DC, you're having these arguments in state capitol, well, then local news, media, and others would be trying to engage, build your participation in that process at the state level. And there are individuals thinking at the national level, maybe less emphasis, right? The idea is that if the Supreme Court says, no, the federal government, Congress can't pass laws that give broad powers to the executive branch, well, if you don't have the power there and it's at the state level, then we got to shift our attention to from the national to others. We'll leave group for a moment and then looking at organizational, right? So imagine you're an organized interest, economic interest, say you're a coal company. Well, if you're successful in this ruling, you're like, yay, we get what we wanted. But now it shifts from a national to a state and local level. Now, maybe in the state of West Virginia, which we know is a very, what we call coal country, very strong culture of coal mining and using coal as energy production, they might not be too worried about it, right? But in neighboring states where you might have a different population, a different view on the impact of coal, well, now you're going to start seeing a few more debates in state capitals in that part of the country. For organizations at the state level, we might see increased competition for agenda time and resources. So what I mean by this is that if you say an issue is no longer a federal issue and it's a state level issue, well, state level elected officials, governors, state upper house and lower house elected officials, they have to deal with the whole range of things. And now you give on their plate another thing they have to deal with. So there's going to be increased competition for, what do we deal with? How do we deal with it? How much time and attention do we give it? And then lastly, organizations at the local level might say, well, if we're not looking at the national level anymore, we might want to focus on the state level, even though these things might be determined at some local level by cities and counties. And the reason is that we know that the states can pass laws that would preempt. And what this is basically this, if the federal government isn't going to exercise its power, not allowed to, states will exercise their power. And one thing they can do is say, cities and counties, you actually can't pass laws that regulate greenhouse gas emissions. That's up to us at the state level to deal with. So you might see this kind of convergence onto the state level by organizational groups to either protect the status quos that they've established or to defend them and or to change them and to alter them. So with that, I'm going to go ahead and say thank you for listening in. I appreciate your engagement, and then we'll go ahead and get to our discussion. So with that, take care and have a good night.